Great. Good evening, everyone. I see a steady flow of attendees coming into the room. We will wait a few minutes, probably a minute or so before we begin, but I'm very happy to be here this evening with Julie and Professor Rubenstein. We will introduce them shortly. And for now, we will sit tight for a minute or so as people start tuning in. Thank you. Great. So it's almost 5 past the hour, so I think we can start with introductions and welcoming all of the attendees. As you will see, just for some preliminaries, by the way, I'm sorry, my name is Leon Castellanos-Jankiewicz, and I'm very happy to welcome both Julie and Professor Rubenstein to this evening's chat and the attendees on behalf of the Netherlands Network for Human Rights Research, of which I have the pleasure of being the academic coordinator, based as I am at the Asser Institute for International and European Law. Just as a preliminary comment, this session is being recorded and the attendees can participate by using the chat. We will be monitoring that as we move forward, so please feel free to use that or the chat to interact with each other and with us. I will briefly now introduce both our speakers of today. Julie will be in charge of introducing our main guest for tonight, Professor Rubenstein. And I see now a question from Guy Marsh, who asks whether we'll have access to the recording. And yes, we will be posting this on the website of the Netherlands Network for Human Rights Research, and perhaps Julie can tell you where else it will become available. So stay tuned for that as well if you cannot stay the whole evening. Great. Well, I'm very happy once again to be joined here by Professor Rubenstein and Julie. Julie is a longtime friend and colleague, and Professor Rubenstein is our special guest. And of course, we're going to talk about COVID and the rights of citizens and focus on the Australian experience. Although I do realize that a lot of questions about citizenship can translate into many other contexts, especially the one that we are going through these days in the context of Ukraine and Russia and that specific region. But today we're here to talk about Australia. And that is just to say and to point towards the relevance of this topic and how it touches upon all of us as human rights lawyers, but also as public international lawyers and responsible citizens and scholars. So I'm really looking forward to this discussion and to this engagement with Professor Rubenstein. Before I hand it over to Julie, to briefly introduce Julie. Julie is an assistant professor at the Netherlands Institute for Human Rights. the SIM and the Montaigne Center at Utrecht University, where she specializes in human rights law, international criminal law, and transitional justice. And she has presented at many conferences and held many visiting positions. But most relevantly for tonight, we are at the Netherlands Network for Human Rights Research. Julie's PhD dissertation has been awarded the Max van der Stoel Human Rights Award back in 2019. Her thesis, Every Organ of Society, Social Institutions and the Implementation of International Human Rights Law. The Netherlands Network awards this prize every 2 years on a biannual basis together with Tilburg University. So thank you very much, Julie, for coming back to the network to share with us today with Professor Rubenstein.
Thank you very much, Leon. You do get a commission for every book I sell, so thank you for that. Thank you to the network also for hosting us, and thank you also for acknowledging the context, of course, of war on the continent of Europe. It is an incredible time. So thank you to you for hosting this and for everyone for being here to hold this discussion right now. We are, of course, talking about citizenship rights framed within the context of COVID-19 and Australia. And for this discussion, we are very lucky to be joined by Professor Kim Rubenstein, who is Australia's leading expert on citizenship. Kim is currently a professor at the University of Canberra, Australia, but also a graduate of the University of Melbourne, Australia, and Harvard University in the US. Her expertise on citizenship includes both the legal status, so its legal contours, as well as its intersections with broader norms around ideas of membership, participation, and belonging. She has taught and published widely on these topics. She's also made multiple submissions to Australian Parliament on topics of citizenship and constitutional law. And she's also currently the director of 50-50 by 2030 Foundation, which looks to have equal representation of men and women in all key leadership decision-making positions in Australia by 2030. This is an ambitious goal, Kim, but that's a webinar for another topic, I think. But because of these passions that Kim has and this expertise, she's decided to run as an independent candidate for the Australian Senate in the elections this year. So Kim, welcome to you.
Thank you very much, Julie, and thank you, Leon, for hosting us today. Can I just begin by looking outside? It's actually still very dark here because it is just after 6 a.m. in the morning. And I know it's dark for you where you're sitting, and no doubt for many people around the world. And there is a darkness and heaviness that is weighing upon all of us at this time. And I do want to begin by acknowledging that. And of course, much of what we will talk about has relevance to the scenario. But here in Australia, I'm looking out and I know that there is a gum tree right outside my room, even though as I look out, I can't quite see it. But I do want to ground myself in our environment and each of us where we are, recognizing how precious our environment is for us as human beings and our obligations to look after it. But here in Australia too, to be inspired by our First Nations and their call and connection to country, and to acknowledge the traditional owners on the land on which I'm sitting here, and those in Australia who will perhaps watch this later benefit from, and pay my respects to the elders past, present and emerging. And thank you for the opportunity to do that.
Thank you very much, Kim. I have a first question for you, which is hopefully a simple one, and that is just, what does citizenship mean as a concept, as an idea, and what exactly are citizenship rights? And here I'm also thinking as a human rights lawyer, how different are citizenship rights to human rights?
Great, fantastic. And you would think that that is a simple question, wouldn't you? But it is not that simple, although there are frameworks within which I can help answer that question. And of course, all of us sitting here in this webinar know that we hold formal citizenships of different countries. And so the first a way of thinking about it is in a legal sense, that citizenship represents that formal status of an individual in the nation state. But of course, we don't only think about citizenship in that formal sense. There are so many people who live in countries and see themselves as fellow citizens. In fact, it's the language often of the ways in which we represent our fellow residents, people who live with us within our own communities. And in some ways, that's what I write about as small c citizenship, as opposed to capital C or uppercase C citizenship. But both of those concepts relate to notions of participation and membership. And as you said, notions of belonging. We think of ourselves as citizens, whether we're formal citizens or not, if we feel connected to and respected and feel a sense of belonging to the environment within which we live. And that there are different ways in which we are members, whether it be in a very immediate sense of our local community, or in more formal jurisdictional senses in terms of local councils, or in federations like Australia, where you live in a state territory which is responsible for governing you, and a national territory, but also in an international sense. We use the term international citizenship, being a good international citizen, representing the international community. And the final thing I'd say there is that our identities and our rights, as you identified, and of course is relevant for what we're talking about today, can vary according to different aspects of those explanations that I've just expressed, which is why it can be so confusing and why we can be vulnerable to what I would call as overreach by state power because of the lack of certainty around some of those concepts.
Well, I like what you've just said, and I very much feel a belonging to Australia, despite having been abroad for quite some time now. But I must admit, myself and a lot of other Australians abroad did not feel much love reciprocated from Australia when the pandemic hit and we were unable, or it was very difficult for us to return home. And for many people, that was very scary. They were isolated, perhaps here. They had loved ones who were vulnerable back home. And I understand that there were some 40,000 Australians around the world who were unable to return home, who wanted to do so urgently. And migration, of course, freedom of movement are obviously linked to human rights. And I would have said also very much citizenship rights. So tell me, what went wrong here? What happened there?
Look, I think, Julie, this is something that is continuing to be of concern to me, because it was that COVID provided an amplification of the vulnerability of Australian citizens in relation to a confidence of what their rights are, what our rights are, what your rights are as an Australian citizen, wherever you live in the world. And that very much comes back to the beginnings of Australia in so many different ways. I mean, one, of course, is that the First Nations of Australia and their membership is complicated and represents in some ways the greater complication. And by that I mean, when the British settled Australia, Indigenous Australians, by being born in the territory, were immediately formally recognised as British subjects. And in fact, in Australia, the part of the complication is that there wasn't Australian citizenship until 1948. So between the time of the British rule and the setting up of colonies and then the creation of the Commonwealth of Australia, all of the residents were British subjects and stayed British subjects because of this strong tie to the motherland and a desire not to have Australian citizenship. And even at the time of the framing of the Constitution, there was a discussion, should there be a federal head of power over citizenship? And the framers, who are all white men, all said that it would be too difficult to put citizenship into the Australian Constitution. One, because we're British subjects, and what will that mean? Two, because we are creating this federal system, and what will that mean for state and federal membership? Three, what will it mean for rights when, you know, there are children who are going to be, and they won't have the same voting rights. But most importantly, it was because they were driven by a desire to reinforce nationally a white Australia policy. And they knew there were British subjects who were from Hong Kong and from India. And one of the framers said it will lead to innumerable difficulties if we write about citizenship, because how do we so openly say that we don't want British subjects? And Indigenous Australians weren't even part of their discussion. They didn't even think of them, even though formally in common law. So right from the start, there's been uncertainty about citizenship because it wasn't named. And in fact, the whole framing of membership was under a head of power called the Aliens and Naturalisation Power. So one of the things I've written throughout all of my years of writing about citizenship is, in Australia, we define ourselves by who we are not, as in we define ourselves through alienage, not through citizenship and a positive statement of membership. So that's probably a very long-winded way of beginning to answer your question about COVID, because I would say that COVID amplified those very foundations to our constitutional structure and of our inability to talk positively about what we expect as now citizens, because that term came into being using the aliens head of power under the Australian Citizenship Act of 1948. And that only sets up a legal legislative status, and the rights that flow from citizenship are not even in the Australian Citizenship Act. They're in other pieces of legislation. And as we saw during COVID, and coming back to your very focused question, during COVID, the Biosecurity Act in its most pervasive sense made it unlawful for Australian citizens and anyone resident in Australia to leave Australia. So for a Western liberal democratic country, I think we were the only country that actually had that comprehensive ban on its citizens from leaving the country. I mean, it exists in North Korea, but it was existing in Australia too. And that's something we can come back to. But as you said also, for those Australians who are already outside of Australia, it wasn't the Biosecurity Act, although for 2 weeks, the Biosecurity Act did prevent anyone in India. So it was quite targeted, and Australian citizens who were in India were actually criminally prevented. If they came into the country, they would be subject to criminal sanction. So an Australian citizen not only being prevented, but being sanctioned in that way from returning. But the response and outcry, I think, in that instance was so strong that that only lasted for 2 weeks. But it didn't prevent the Air Navigation Act, which was what the government used to effectively stop anyone coming into Australia, including citizens. And the Air Navigation Act effectively regulated the airlines in who could come in, or actually the numbers. It was through the timetable provisions in the regulations that there would only be approval for timetables that included limited numbers of individuals coming into Australia, which effectively prevented Australian citizens from re-entering. And that has only recently been lifted. So for over 2 years, it's remarkable. It's remarkable.
Well, Kim, you've just made a connection there between the British settlement of Australia and the treatment of Aboriginal Australians and the White Australia policy, and then the specific focus on Australians in India. Is there a connection there that also looks at this uncomfortableness?
Yes, look, I mean, it really was an aspect of, I think, the extreme reaction to that very focused. I mean, there was no doubt that there were extreme COVID scenarios in India, but there had been in England earlier, and there had been in other countries around the world where the Biosecurity Act hadn't been used. They were just relying on the Air Navigation Act. And so in that sense, yes, I think it was fair to say that there was at least the perception, if not the, I mean, we'd have to ask those individuals who proposed it, but there was certainly a perception that this was another response, the sort of the innate starting point for legislators to think about that these people needed to be prevented from coming in. And there was, in fact, during that 2 weeks, an attempt to challenge that decision, and it was unsuccessful, largely due to the framing of the challenge. I'd say that there were broader challenges that in the time frame of the urgency were not addressed, which were the broader constitutional questions that just were not addressed.
speaking about challenges, you were part of a challenge to
Yes.
Australia's laws. This was before the UN Human Rights Committee, which monitors Australia's implementation of the International Covenant on Civil and Political Rights. Can you tell us a little bit about that petition?
Yes, so as I've just said, there's no domestic framework for Australian citizens to be protected. And in fact, in thinking about a constitutional challenge to those issues, it became very clear to me that it would be very difficult to do that within the time frame, because our judicial review framework would have required various successive challenges, both through the first level of the Federal Court of Australia, an appeal to the Federal Court, and then an appeal to the High Court, which would take many years. And I've been involved in cases over the years because I've kept my practicing certificate throughout my almost too many years to mention academic life. So that was one issue. And then Jeffrey Robertson and Lionel Nichols, barristers in the United Kingdom, contacted me to say that they had been approached by individuals. And the approach came from the reality that not only is there a domestic framework, as we know there is an international law framework, but moreover, Australia is a signatory to the optional protocol of the International Covenant on Civil and Political Rights, and Section 12's right of individuals to return to their home country, the right that we think of as citizens' rights to travel in and out of the country, was obviously being eroded. And so they asked me to provide a memorandum of advice, my opinion, on whether those individuals had effectively exhausted their domestic remedies, because as you know too well, that framework requires the domestic avenues to be followed first, and an application to the committee can only be made with that exhaustion of remedies. So my opinion was to say that there was an effective exhaustion of remedies, both because of that time frame that I referred to, and previous decisions of the committee had recognised that if it would take a substantial period of time and the right was such a significant one, that it would effectively deem that the domestic remedies have been exhausted. And that was the point, and the progression of that case had got to the point where there had been a determination that serious breaches were significant for the committee to ask Australia to return those individuals, but the actual deliberation of the breach of Section 12 never happened. And of course, now that borders have reopened, and so it's no longer a live matter.
Yeah, it would have been nice in a way to have that jurisprudence to get some sort of certainty around these rights. So I'm very pleased that those particular petitioners were allowed to return home. But as Elizabeth has said in the chat here, there are many people who have been and continue to be stuck abroad.
Yes.
And this issue goes to a question that has been posed by Annette. And she talks about the right to vote from abroad. And I see these issues as linked up because, of course, we were disadvantaged in a way by not being able to return home. So can't we then, as a democratic response, vote out the current government and have our voice heard in this democratic way?
Indeed.
But, of course, for those long-term people who are abroad for long-term, we're not able to vote. So is this not also then an issue of franchise and citizenship rights?
Absolutely, absolutely. And I do think that they're, as you've just said, they are fundamentally linked, and in many ways fundamentally linked to my sense of myself being activated to put myself up as an independent candidate at the next federal election. And I should also say that I'm on leave at the moment from my University of Canberra and 50/50 Foundation position. I'm on leave so that I can concentrate and bring in this skill set that we're talking about today into a more active sense of wanting to be a representative here in the ACT, but calling out really to all Australians to say that my role in the Senate would be one where I could advocate very much on these issues. And this is one that I have obviously become passionate about and is relevant to what the skill set that I could bring into Parliament. And it is a very real question. It's a live question, in my view, about the constitutionality of that section 94A of the Electoral Act, which effectively requires an Australian who is overseas to within 3 years. So if you're, as soon as you essentially leave Australia and you make the determination to stay away from Australia, the Act provides that you have up to 3 years to register. But there is also a requirement that you have an intention to return within 6 years. Now, for those who are bona fide in their understanding of their place in the world, and perhaps as human beings, we can all say, who could know where you're going to be in another 6 years? Over 20 years ago, when I was teaching you, Julie, migration law at the University of Melbourne, how could either of us have known where we would have landed within the next 6 years, the next few years, let alone the next 6 years? However, the Act requires a person to say that their intention is to come back within 6 years, and you can register. So a call out in and of that statement to all the Australians who haven't been away for 3 years yet, to make sure that you register. And at the end of this, we'll give you a link to be able to do that. But for those who are in your position, Julie, or Annette's position, or others who have been away for longer and have not registered and have effectively been disenfranchised, I think there is a profound constitutional question as to whether a government can disenfranchise a citizen when it continues to have the reach over you, not only in the sense of preventing you as an Australian citizen from returning, because you're still an Australian citizen, it's just you're not entitled to vote. So they're saying not only are you not entitled to vote, but you do not have an entitlement to live with your family in Australia or to return at any point when your family is in need or for whatever reason as an Australian citizen. And in addition to that, as we know in international law, the Australian government continues to have reach over you in its laws. The notion of extraterritorial legislative power. So any Australian, wherever they travel in the world, is subject to Australian law if there is a connection that the Australian government seeks to make. There are criminal laws that apply to you, Julie, wherever you are as an Australian citizen. And perhaps more profoundly, and an area that I would also continue to advocate on, is the changes in the Citizenship Act to dual citizens, in that a dual citizen who does exactly the same thing as a single citizen, and there are specific acts at the moment that have been identified as reflecting a non-allegiance to Australia, you can have your citizenship stripped from you while you are abroad by virtue of the fact that you do have another citizenship. But in a way that for me as a single Australian citizen could never happen. And so there are so many profound ways the Australian government continues to control your life, but is stopping you from having any say over that. And that does not sit very well with, I think, liberal democratic notions of membership or citizenship. And I think that there are real constitutional questions, obviously not clearly stated in the Constitution, as I've said, but constitutional principles in a liberal democratic society that professes and has a constitution to represent the rule of law. Is it possible, and can a court, and I would say that there are very strong arguments, say it is beyond the reach of a government to strip an individual of citizenship just because they're living outside of the country when the laws continue to apply to them?
Yeah, and especially in Australia, because we have compulsory voting as well. So on the one hand, there's this sort of duty to vote. And then on the other hand, at the same time, they're disenfranchising certain people who do want to vote. In the chat, we've seen some people asking about any advocacy or lobbying to actually change this in Australia so that there is some way for Australians abroad to vote. And what sort of representation they would have. I know in places like France, there's actually sort of a representative of French people abroad. What would we have to do in Australia to fix this?
Yes, and I think that's also in Italy as well. There are some Australians who are members of the Italian Parliament as the representatives from abroad. So it's not a new concept, but it is not yet a concept in Australia, and that would require some legislative and possibly. I have to come back to think about what you would need to do to affect that. But and I think it would be possible. So we'll put our thinking caps on in relation to that. But the earlier question in relation to the lobbying power of Australian citizens, I mean, of course, one aspect is to support campaigns of people who are running on these issues that affect them. But there is actually a very empowering history of Australians abroad. There was a group that was set up during the time when the question about dual citizenship in Australia was a very hot issue. And by that, I mean, there was a period from the time when the formal status of citizenship was established in 1948 until 2002, where anyone born in Australia and who became an Australian citizen by birth or was living in Australia and had citizenship by descent by virtue of another country's laws, not by them applying for it, but by virtue of their parents' citizenships effectively being bestowed upon them at birth. Those individuals, if they went to another country and became a citizen of that other country, they lost as a matter of law. There was a section that said that any Australian citizen who took up a new citizenship effectively lost their Australian citizenship. So it prevented dual citizenship. However, if you were a migrant to Australia and you became an Australian citizen by naturalisation, as the term was called originally, or by conferral later, then there was nothing in Australian law which required you as a matter of law to give up that former citizenship that you obviously held. So it depended on that other country's citizenship laws as to whether they enabled you to keep your citizenship. So there were many, many Australian citizens who were dual citizens by virtue of that fact that they had another citizenship first and they were taking up Australian citizenship. Yet Australian citizens couldn't then take up another citizenship. And many Australians living abroad like you began to really question how fair that was, particularly when they were not able to take up the citizenship of the country they were living in. And I'm sure that's many of you here in this Zoom room. And didn't want to give up their Australian citizenship, but were because they continued to have a commitment and connection to Australia, but were being disadvantaged by not being able to become citizens of where they were living. And so the Southern Cross Group started lobbying and asking those individuals to write to their parliamentarians. And there was actually a review in 1996 that almost got through to a proposal to change, and the government of the day got cold feet in relation to it. But by 2000, a broader review was done of citizenship, excuse me, and a recommendation was put that be repealed. And then that led to another more high-powered lobbying effort by those Australians living abroad. And finally, legislative change occurred. So that might be a sign of hope to those of you living outside of Australia who really have been affected, to raise your voices, to lobby your family's representatives, because your families are similarly affected by your reduced citizenship, and they can have a voice for you directly in their vote if you no longer have a vote. But for those of you outside of Australia within the 3 years who have maintained your position on the electoral roll, this is something that you can very clearly express your right to vote, that you don't think it is appropriate for other citizens like you who didn't happen to put their name on the roll within those 3 years, or were bona fide in not being clear that they would come back within 6 years. Why are those requirements still there? And our legislative Parliament can change that, and I certainly would be advocating for that if I'm a member of the Senate.
Thanks, Kim. I think it is good to be optimistic here, because laws can and do change. And I know the UK had a similar law which prevented citizens abroad from voting after 15 years. So 15 is already a much bigger length of time than Australia. Australia's got one of the shortest timeframes within which you're disenfranchised. And I understand that the UK current government is looking to change that, in fact. So,
so there's an international effort here.
Exactly. Okay, well, you were talking about also stripping of citizenship, and there's a question in the chat that relates to foreign fighters. And as you mentioned, it was Australia's policy to strip citizenship of those foreign fighters where possible. So perhaps you want to reflect a little bit on that in relation to Australians who went over to fight with ISIS, but also in the contemporary context of the conflict in Ukraine at the moment, because the Ukrainian government has invited fighters to come and fight alongside them. Would that also then, would Australia's policy also apply to those individuals?
Yes, thank you so much for raising these issues. They are absolutely pertinent, and they are, I think, really ongoing concerns about the legislative framework for citizenship in Australia. The first thing I would say is that that any government has obviously a responsibility to its citizens wherever they are to protect them from foreign fighters. But the framework that I believe that should be expressed is in our criminal law frameworks, or in questions of treason, not in terms of the fundamental citizenship framework of a country. To merge the two and to use your citizenship as, in effect, a framework for punishing those individuals or for protecting those others who would be subject to their work is undermining the sort of liberal democratic framework, because you necessarily, and in the way Australia has done it, distinguishing between dual citizens and single citizens, you create an inequality of citizenship, and you disrupt citizenship as a framework for social inclusion, for creating a just and sort of a society that is based on human rights principles that always have to be balanced. Of course, they're not absolute, but using that framework is problematic. But it is also, I think, problematic in the sense of the rights that we afford for those individuals. Now, we actually have a case in the High Court at the moment. I sat here in Canberra in the High Court, disappointed because I was just sitting watching it on the screen, because each of the High Court judges were sitting in their chambers in their own states, and counsel was sitting in their own chambers. So the group of us who came to watch it live in Canberra, we're not actually watching the participants directly in front of us in the room. But there is a case at the moment of Alexander and the Commonwealth, where an individual is deemed to have, by the Australian government, to have Turkish citizenship, even though Turkey is saying that individual is not recognised by them as a citizen. So it raises really interesting questions of statelessness in practice. He is in a jail and has been alleged to be a member of ISIS. I understand his claim is that he was tortured, and that's not, in fact, his story. But aside from whether he is or isn't, there are really serious questions about statelessness, of effectively making individuals stateless. But I think more profound questions in terms of rights protection and the Australian government's capacity to really monitor and protect other Australian citizens, because once you relinquish someone of your citizenship, it also takes away from your extraterritorial powers. And so what does that say about Australia's international citizenship, being a good international citizen, where we're saying we're ridding ourselves of this individual and we're leaving it to the rest of the world to manage this particular person? And when the other country that Australia deems is the formal citizenship also says, well, they're not one of our citizens, then whose responsibility is it to protect that? All citizens from that individual, but also that individual whose rights have not been properly accorded. And if is criminally responsible, should be criminally responsible to one of the countries it is a citizen of. And that would be something that Australia as a nation could say to those Australians in Australia, we are protecting you by actually being responsible for that person, rather than from releasing them from our responsibility.
Yeah, I think it is kind of a perverse reaction in that sense, because you then actually undermine your abilities to actually control that person. And you're talking about criminal law, but I'm also thinking about international criminal law here, and the fact that the Rome Statute applies also by virtue of nationality. So if somebody is, for example, an Indian and a Chinese citizen, and you take away their Australian citizenship, India is not a party to the Rome Statute. So therefore, that court wouldn't have jurisdiction over that individual either. So it creates more problems, perhaps, in addition to, as you were saying, also other issues regarding statelessness, which are real issues too.
Yeah, indeed, absolutely.
I have a question about Australia, and I think some of these issues would be easier to deal with in Australia if we had actual human rights protections in our legislation formally, like a Bill of Rights or our Constitution. Yes. And you mentioned before with the petition before the UN Human Rights Committee, the fact that this doesn't exist was one of the reasons why you went straight to the committee. And my
Yes.
question is, why do you think Australia has been so reluctant to legally, formally protect human rights in our national law?
Look, it's a really profound question. And I think it comes back to that same starting point in terms of the creation of the federal constitution and the basis upon which it began, which involved what was contemporary for the time, a discriminatory framework and a recognition also. So there's that sort of negative aspect to it, that they were seeking to restrict rights. So they would not have formally thought of bills of rights at that time in 1901. But perhaps a more positive representation of it was that belief in the British common law system, that it would be, that there were essential common law principles that judges would uphold. And so it wasn't for Parliament to be, legislating or constitutionalizing rights. That was the role of courts, was for the courts to do that. But what we've seen over that century and a bit is that courts do recognize some rights, and they would be rights that I'd be advocating if we were able to progress some of these discussions within the courts in terms of essential constitutional citizenship or membership principles that, even if they're not written into the Constitution, are so fundamental to a rule of law society that a court would say that they were implied, in a way that the Australian court has recognised and implied freedom of speech associated with representative democracy. So there are avenues for that, but I think that reflects on that feeling at the time. Now, if we jump from 1900 to various periods of time in Australian political evolution, there have been attempts by some governments to engage with a federal Bill of Rights. And we have seen here in the ACT where I sit, there are state or territory rights frameworks. Victoria also has a Charter of Rights. So in a federation, you have different ways in which you engage with it. But if you don't live in a state or territory that has that legislative rights protection, you don't have that. And I do think that, again, during COVID, we've seen government overreach, not only in relation to the movement of citizens, but in other aspects of internal movement within Australia. And of course, the rights issues that are coming up in terms of vaccination and so forth. Now, rights are not absolute. We know that as scholars, but we also know that practically. And it is time, I think, for our Parliament in a legislative sense to grapple with those issues. And I think also we've had a raised consciousness in Australia of individuals by virtue of that government overreach, that it is something that needs to be deliberated on in an engaged and informed and thoughtful way, not in a partisan way. And I think that probably comes back to where I am at the moment, that we've seen over the last couple of years, and, such partisanship, which I meant by that, I mean the party politics taking over the policy. And we really need, as a nation, to engage with that policy in a way that benefits everyone and is not divisive and destructive.
Yeah, I think that partisanship has been experienced in many different parts around the world and has perhaps been exacerbated also by social media and the miscommunication that seems to come from that in many ways.
Yes.
I was thinking about Australia and not only citizenship stripping, but also how one gets citizenship. And we've got a question in the chat that looks at avenues in which that one can acquire Australian citizenship. And the question here is about somebody who is an Australian citizen but lives abroad and has a partner who doesn't have an ability to get Australian citizenship while living abroad. So I wondered if you could reflect a little bit about pathways to citizenship and the way that Australia conceptualizes this.
Yes, so I'll try. I'm conscious that we've got another 15 minutes, but there's an entire hour in this. But very shortly, there are different ways to become a citizen. Obviously, birth in territory is one, but when I say obviously, that has also changed over time, because at the beginning it was just birth in territory was sufficient, but in 1986 it was changed to not only birth in territory, but in addition to being born, you need a parent who is an Australian citizen or permanent resident to automatically become an Australian citizen. And if you're born in Australia since 1986 and neither of your parents fall in that category, you are not an Australian citizen. And you only become one if you continue to ordinarily reside for 10 years in Australia. So there are many people who are born in Australia who are not Australian citizens. You can apply to become a citizen if you were born outside of Australia and one of your parents is an Australian citizen, but it's not automatic. You need to apply. And if you, up until the age of 18, have the proof that one of your parents is an Australian citizen, then there is no reason for you not to be successful, but you actually have to apply. But after the age of 18, there is an extra requirement that you be of good character. And so that's something that can be problematic for individuals if they've been found guilty of certain criminal offences, even if they're not necessarily, no matter what the outcome or the circumstances. So that can be problematic for individuals. Now, the question of marriage is interesting and problematic. There is no automatic right for someone to become a citizen by virtue of marrying an Australian citizen. And as the person who has put the question has raised, it's through a migration framework. So if you're not planning to spend time in Australia, and if the nature of your life is such that you're outside of Australia, then the residence requirements really effectively preclude partners from becoming citizens. There is a provision where the residence requirements recognise that if there is something that you are doing while you're outside of Australia, which is of benefit to Australia, or shows a close and continuing association with Australia, that may be an avenue. But I've been involved in a couple of cases where I've sought to argue that that close and continuing association comes from just being a partner of an Australian citizen, and not only just the concept, but actual practice of travelling back and forth and being connected to Australia, of individuals that have not so far been successful in the tribunal framework. And again, I think that there are profound questions that I appreciate the questioner asking in terms of preventing families, because if we think about that, and this is another entire aspect of citizenship and membership, family relationships are core, and this has a very gendered element to it. And we know historically that women had their citizenship stripped from them when they married non-citizens or non-British subjects. And we're really not talking that long ago. And there are indeed some countries in the world today that are so gendered in their application of citizenship. So that's another entire discussion.
Yeah, one thing I think about COVID is that it has, certainly in Australia as well as around the world, used the language of human rights,
Yes.
sometimes obviously very incorrectly, but it has
Yes.
been interesting that there has been this public recourse to the language of human rights and people sort of
Yes.
calling for their rights on both sides of the debate
Yes.
here.
Yes.
And that I
Yeah.
think is perhaps something good, that people have sort of, sought for these sorts of norms.
Yes.
But a question that comes in the chat is from Tina, and she has asked about the rights of West Australians
Yes.
and what has happened here by the Western Australian government in relation to the pandemic itself. So perhaps
Yes.
also looking at something at the federal
Yes.
level or the state levels, as you
State
mentioned
level.
before.
So yes, thanks, Tina. And this is really an ongoing issue, as you know, because there are still border restrictions internally in Australia. So we've opened up our external borders, but we still have the state of Western Australia asserting its right to keep its borders closed. Now, this leads us into one of the sections of the Constitution, Section 92, which talks about freedom of interstate trade and commerce. And effectively has a notion of rights protection largely driven by economic concerns rather than a freedom of individuals' movement. But it does have an impact, obviously. And there is an interesting jurisprudence around that section, which says that even in that framework of an economic framework, if the state is doing it in a way that is not proportionate to the reason for its closing of the borders, and in this scenario, of course, it's a health reason. So if there is a strong enough case to say that, in fact, what the Western Australian government is doing is protectionist, and that protectionist notion is in an economic sense, then it could be found to be unconstitutional. And there are, again, questions that I think people are still thinking of running in the court in relation to the overreach of the Western Australian government, that in light of vaccination levels in the country, that it is no longer strong enough to say that this is a necessary restriction in terms of the health scenario. But again, a court would then have to assess that balancing act of the responsibility of the legislature in Western Australia to protect those in Western Australia from COVID with the rights of interstate trade and commerce and the implications for individuals who are not able to move by virtue of that. But I think what it reminds us, and this is another sort of level of discussion, is our federal system in Australia has become fragmented. And what we had an absence of, which is both in the external sense of what a federal government could have done to both protect Australian citizens abroad and those within Australia. It has a power. One of the powers it does have under Section 51, there's no power of citizenship, but there is a quarantine power. And the government could have set up quarantine stations around the country that were purpose-built for COVID. It would have stimulated the economy in terms of construction. We know that there are very quick ways of setting up, places that are habitable and that are safe and that would have been COVID safe to enable Australian citizens, both abroad and those here who wanted to go and visit their family. I mean, 49% of Australians were either born outside of Australia or their parents were born outside of Australia, which means that, up to 49% of Australians have family overseas. They were prevented, and many of you in the chat I can see are still stuck, prevented from that human need to be connected personally with their loved ones. The Australian government could have protected those individuals by creating quarantine stations around the country and enabled that travel. And similarly, we could have had a national response internally, but we come back to what I believe is the partisanship and the party politics that ultimately was stronger in influencing discussion. And I think a fear factor. I mean, there's no doubt that many Australians, even in those situations, were fearful of travel. But that's one thing to say, that we use that fear to then undermine your other people's capacities. Fear is real, but a nation and its leaders should protect people, provide them more information to reassure them that sure, that we are in unprecedented times, but we have ways of managing that where we can look after citizens wherever they are.
Thanks, Kim. I think that's a really nice statement, and it ties back to what you were saying about how human rights are not absolute. It is always about this weighing, this balancing, this question of necessity and proportionality. And Elizabeth has corrected me in the chat and said that it's not enough just to sensitize people about human rights. We have to also educate them about human rights. And the fact that they aren't these absolutes, but rather these tools that we use to protect ourselves and one another in a democratic society.
Yes.
So I want to come back to you then, Kim, and ask, what do you think needs to be done about educating people about human rights in Australia? And where do you think we have room to move there?
I think we have a lot of room to move. And specifically to that point about the sensitize versus educate, because one thing we have seen in Australia has been a rise of a more populist reactionary response to rights protection. And here in Canberra, for a couple of weeks, we were inundated by people who identify as sovereign citizens who said that their rights overrode the state in relation to their capacity not to be vaccinated, and to a very strong reaction, which I do think is a reflection of that fear of individuals, and perhaps more problematically, a loss of trust in our leaders. And so I think that there are various ways, and integrity in our leadership is a key way of starting to deal with that issue. And that's that broader political question that I'll come back to in terms of my own decision to run. But I think in terms of rights education, I think there are avenues within our civics and citizenship frameworks, given Australia is a signatory to these international conventions, that we could be educating our children in these, and as frames for thinking about how we live as fellow citizens and treat each other in terms of with respect and dignity. I mean, all of the principles underpinning our human rights frameworks are about how we treat each other as human beings. There is so much harassment and bullying. I mean, these are the broader equity issues in society and gender issues in society, but human rights frameworks become a very healthy way of looking at the balancing act in society, of how we act in our own interests, but how we also recognize our role as fellow citizens, as members of a community, and the balancing of those issues, and how they are so nuanced, and what we can teach our students that nuance is a positive thing. You know, so much of politics is about absolutes in order to get a message across. You know, it's almost the lowest common denominator approach to public discussion. And I don't think people need to be interested in academia to know and really get how governments impact on their lives. This has affected so many individuals, both locally and internationally, that there's such a profound practical experience of people now about government overreach. We need government in our lives. There's absolutely no doubt about it, to regulate large communities. But there are points beyond which it's improper in a liberal democratic society for governments to act. And if the citizenry don't have the basic foundations of being able to articulate that, then that becomes a breakdown of a liberal democratic society. So it's fundamental in a liberal democratic society that we teach our students that, our law students. You, Julie, as one of many of my students over the past, I hope and believe, go out into their world as lawyers, very conscious of their responsibility to society with the skills that we've each been given as lawyers, to really ensure that we keep our government accountable and that we assist our fellow citizens in representing them when they are in situations where government has acted improperly or have provided a decision that doesn't take into account the seriousness of the impact on their lives. And I think that perhaps is one of the silver linings of COVID, that people are able to be aware of those things. And then it's a responsibility of our leadership to deal with the fear that leads to those extreme reactions where human rights become seen as absolute in what I would say is a negative sense, where there is a disregard for the needs for others in the community. It's always a balancing act. Nothing is absolute. And we've got to ensure that, that those who are fearful and therefore are encouraged to become extreme are protected and supported, and not seen as other, not just disregarded as being on the fringe, but our fellow citizens, who we have a responsibility to ensure that they are less fearful and provide real mechanisms for them to feel less fearful.
I think it comes back to what you're talking about at the beginning about citizenship with the lowercase c.
Small c, yes.
And that across multiple levels. So that's not only citizenship in terms of your community in Australia, but also perhaps regionally and also as international citizens. And I think you're right that COVID has reminded us that we live in communities, and what happens to one of us impacts those around us as well in a very concrete way.
Yes.
I'm going to wrap it up there. I think we've come full circle. Thank you.
We have. I know that there are lots of other questions in there, and perhaps for those we haven't directly answered it in the chat, I'm definitely contactable. My email, and perhaps I should put it in the chat here, is because I'm on leave now, I'm giving you my campaign email address, which is kim@kimforcanberra.com.au. Please email me if you have any further follow-up questions. The last thing I would like to do is, if I can, Julie, in the minute or so, and Leon in the minute or so, some people have asked how you can support my campaign. And for any Australians anywhere in the world, you can by going to and having a look at my website, which is the Kim for Canberra. If you look for that, you'll be able to Google that very easily. I think
it's in the chat. It's in the chat. Yeah.
So thank you very much. And I also want to call out and make a shout out to Jock Gardner, who is an Australian who's normally based overseas, who is a volunteer for the Kim for Canberra campaign and who is coordinating Australian citizens outside of Australia to support me. Please contact Jock. And if you go to my website, you'll see on how to get involved, there is now a tab about registering to vote, and within that there are links to how you, if you're within your 3 years, can register, and those of you who are already registered, the special provisions that enable you to vote in this forthcoming election. And that to me is the biggest, regardless of me running, and you may not even be an ACT resident in terms of directly being able to vote for me. I really, really want to impress, as from my own person, regardless of what role I'm playing, that you be active citizens, that you really influence and have a role to play in the future of Australian democracy. And to thank you again, Leon and Julie, for enabling us to make that call out to Australians to exercise their rights, and to all the great work that you do in your respective roles in the various organisational frameworks that have supported this today.
Thank you so much, Kim. I'm feeling quite inspired. Thank you so much for your time. Thank you also, Jock, as Kim said, for helping put this together. Thank you to Leon and the Netherlands Network of Human Rights Researchers for hosting us. I hope everybody stays safe in these times, COVID, but of course, the war. Leon, I'll hand over to you for the final words.
Thank you so much, Kim. This has been a very, very lively, interesting, and engaging, as Julie said, session. I have nothing to add except to thank you and hope to see you again at the Netherlands Network for Human Rights. You're always welcome.
Thank you.
So let's please stay in touch. And of course, everyone, we will post this video online. Please share it with your friends if you think they're interested, if you think it's relevant for them. And you can find it on the website of the Netherlands Network for Human Rights Research, which I am posting now. And surely via Julie's Twitter, you will be able to follow up on many of these issues. So thank you all very, very much. Julie, you have raised hand? No, you good? Okay. And hope to see you again soon, and have a great day. Have a good night, depending on where you are.
Thanks, everyone. Thanks, Kim.
Thank you.
Ciao.
Bye.